Patty, good to see you again.
Thank you. You too. How's it going?
Fast and furious here in Talent. Never a dull moment. Though I gotta say, I just got a text from a staff member. They've been watching a lot of the instructional videos that you've made on LOC.
Oh, okay.
So you got a big fan in the audience tonight.
Oh, good. That's nice. Those videos are very hard for me personally. So when I teach, I like if I teach an all-day class, I will walk like 15 or 16,000 steps. I use my hands and I'm very expressive. And when we film those, the camera crew was like, "This is your box and you're gonna sit." And I was like, "You were messing with my mojo, people. This is not how I communicate successfully."
I know. Things going well at LOC?
Yeah, I'm pretty fast and furious here too. We have our spring conference in 2 weeks, so we're kind of trying to figure out some last minute logistics and stuff like that. But yeah, probably just like you guys, right? It never ends.
Jordan, I think I see the mayor in the audience. Attendees, I see Heather Ayers Flood. I'm going to guess that's our Darby.
We'll have Hector promote.
Hey, Hector.
Hello, Counselor. I've promoted her. It doesn't move her. I've tried several times now to promote Heather Ayers Flood to panelists, assuming it's Darby, Mayor Darby, and it doesn't allow me to do that.
Oh, looks like Hector, I can. Mayor, if that is you under Heather Ayers Flood, could you just send a chat to us and we'll know that?
Hey, can you hear me?
It worked.
This is Heather. It's Heather. Darby's joining on her computer, and I'm coming in as a member of TPAC to listen to this incredibly scintillating meeting that we have coming up.
Thanks, Heather. You're getting the honorary promote here.
I didn't really want to promote. I just wanted to stay as an attendee, but whatever,
Yeah.
whichever is right, I'm just here to listen, really.
Perfect. We'll go ahead and put you back into the audience so you can eat dinner in peace while you listen.
Sorry about that.
And welcome folks as they trickle in. Patty, we must admit it's a beautiful day here in Talent. And so if folks are reluctant to join their laptop screens, I can understand why.
I get it. I went outside to get lunch with my niece, and same concept. I was kind of thinking, oh, it's not a great day to have to stay inside.
Absolutely. And Gerlinda, I see that you've joined us tonight too. Wonderful. Just so you know, this is a study session for this first hour, and then we'll switch to the council meeting at 6:45.
Fabulous.
Great.
Have we already opened the meeting? Oh, you guys waited for me. Oh my goodness. I love that. So with that, I'll call the study session to order at 5:48. Roll call, please.
Councilor Clark,
Here.
Councilor Ponomaroff,
Here.
Councilor Greider,
Here.
Councilor Pastizo. I don't see Councilor Pastizo in the panelists. Councilor Byers,
Here.
Councilor Parra Miller,
Here.
and Mayor Ayers Flood.
Here.
Mayor,
And
you
I'll
have,
go ahead. I'm sorry, Hector, please.
thank you, Mayor. Excuse me. Mayor, you have a quorum.
Thank you. I apologize for interrupting you. I will go ahead and text Councilor Pastizo and see if he can make it. So with that, we'll move on to item number 2, which is meeting accessibility. Hector?
This is a question for our attendees. If any attendee would like this meeting translated into Spanish, to please raise their hand now. Y una pregunta para el público. Si alguien necesitará esta reunión interpretada en español, por favor, alce su mano hoy. And I'll watch the attendees, Mayor.
Thank you, Hector. So the next item on the agenda is item number 3, the League of Oregon Cities Public Meeting Law Requirements and Best Practices. Staff?
All, thanks for joining us tonight. We are joined by Patty Mulvihill, who is the Executive Director currently for League of Oregon Cities, to give us a little training on public meeting law. Just to remind everyone here, we'll be in the study session and then we'll just transition into our regular city council meeting at 6:45 p.m. And folks are welcome to have cameras off and eating dinner, all that's needed to keep yourself fueled. And Patty, with that, I will turn it over to you.
Thanks for having me back. This is my second time giving a presentation, so I won't spend a whole lot of time on my introductions. I think I've met some of you before, but I'm Patty Mulvihill. My background is I spent almost 13 years as an in-house attorney working for a community in the Midwest. I've been with the league for about 5 years, mostly in a legal capacity, but we've had some recent leadership changes at the league. So I'm the interim executive director as of December of last year, expected to stay in that role through the end of this calendar year. So today, what we're going to talk about is public meetings. Oops, it says the host has disabled my screen share abilities.
Hector, are you able to do the sharing?
I returned the permissions. I'm sorry about that, Patty.
That's okay. It happens. After 2 years of COVID, I'm nothing if not adaptable at this point, right? Is that how everybody feels? So let me put this in slideshow. So why are we not? Did they change their thing again? Well,
If you go to slideshow in that same bar where
oh, there we go.
it is,
There we go. There we go. Sorry, it's been a while since I've been on Zoom. You are the only people I have taught in the last 4 months, and I used to teach 3 or 4 times a month. So thank you for the assist. So we're going to talk today about public meetings in Oregon. You all are in a public meeting right now. You're probably in public meetings most of the time you're meeting. And there's a couple of things that you are required to know and understand and follow pursuant to Oregon's public meetings law. Some of them are pretty clear under statute. Some of them are requirements made by judicial opinions. And some of the stuff that we're going to talk today about are best practices. I always preface this particular session by saying when we provide information on best practices, particularly when it comes to public meetings in Oregon, the league takes a conservative view of the case law. And the reason we do that is because our cities range from really big cities like Portland, who have over 30+ attorneys on staff, to smaller cities like yours who probably use a contract attorney, so you have a limited amount of budget. And we take the conservative approach so that if you follow our advice, you are less likely to be sued, and if you get sued, more likely to succeed on the merits. I always jokingly like to say, if we're gonna live in the gray world and kind of challenge what might or might not be with the law, it's a lot easier for the cities who have an attorney on staff to make that, because they pay that attorney the same amount of money, whether that attorney works 40 hours a week or 80 hours a week. So the advice in here is conservative. That doesn't necessarily mean there aren't other interpretations for you to consider, but just something for you to be aware of. So we're going to start with the basic legal requirements. I said this last time when we did a quick training, but if you have questions or comments, please feel free to interrupt me. There's only 3 of you that I can see on my little Hollywood Zoom square line, so I won't see you if you're raising your hand. You're just going to have to interrupt me. It won't be offensive. I won't be upset. Please just do it. So the first basic question that you have to understand is what is actually a public meeting. And a public meeting is a specifically defined term under the Oregon Code, and it's the convening of any governing body for which a quorum is required to make or deliberate towards a decision on any matter. That part is clearly in the statute. The Oregon Attorney General has expanded that and opined that if the governing body convenes to gather information, that too can be a public meeting. So even if you're not making a decision as a council, if a quorum of you get together just to learn about something, that is considered a public meeting, at least as far as the Oregon Attorney General is concerned. And as a result, the league always encourages our members, if you're just gathering information, even if you're not making a decision, you should strongly think about noticing that event as a public meeting. Now, the statute also talks about when a quorum is required. And so a couple of years ago, some cities and counties argued, well, what if we just don't have a quorum? What if we don't say what a quorum is in our charter or in our municipal code? Can we still meet then? And the court came back and pretty specifically said, everybody knows what a quorum is, even if you don't define it in a charter. Quorum is one more than half. So you can't kind of circumvent the statute by trying to play around with whether or not your council has a quorum or not. The court's going to look at it and say, there's a quorum. We can easily find out what it is. And if a quorum of you met, you have to publicly notice it. Embedded within the public meeting requirements is that you cannot vote with secret ballots. Where I sometimes see this come up the most often, particularly with city councils, is when you're being asked to appoint someone to fill a vacant council seat or to fill a contested position on one of your city committees. A lot of times people are really uncomfortable with having to pick between two viable candidates for an open council seat. It just maybe feels a little uncomfortable. And councils will regularly ask, can we please do that by secret ballot? The answer is no. That's very clear under both the statute and the case law. What's also interesting and important to know about the public meeting definition is it applies to your committees and your subcommittees. So this is your planning commission, your budget commission, your urban renewal agency. Any of your committees or subcommittees are going to be subject to the public meetings law. And this can be committees that you create internally yourself. So let's say, for example, Talent wanted to study the houselessness crisis in your community, and they want that committee to gather data and come up with potential solutions to share with the city council. If the committee that you create, even if it's entirely comprised of citizens, if that committee has a responsibility for giving advice to the city council, that committee is automatically subject to the public meetings law itself. So you want to be mindful when you create committees that in creating them, you could be creating requirements for public meetings compliance as well. Some cities have decided in certain instances that when they create committees, they'll have the committees make their recommendations, say, to the city manager instead. So if you had taken that same committee to study houselessness and you said, okay, you're going to study the issue and you're going to make recommendations, but the recommendations are going to be given to Jordan, then that committee wouldn't be subject to the public meetings rule because they're giving advice to the city manager, not to the city council instead. So just make sure that you consider this whenever you guys are talking about creating new committees.
Question?
Yes.
So this, I think, actually came out, another city did this. They were deliberating in open session and somebody said, you know, we really ought to go ask some other official in some other body this question. So, but we don't want to send quorums, so we'll assign 2 or 3 counselors to go talk to this city official, county official, or somebody about such and such, and come back and tell us what they said. Is that something that should have been subject to public meeting law or not?
Potentially, it would depend specifically on how it was created. So remember, the Oregon Attorney General says gathering information can constitute a meeting. So if you had created that committee to gather information and a quorum of that committee, for lack of a better word, met without publicly noticing, you could have done it. That's potential, but you'd want to know how many members of your council participated and what were they actually asked to do, as opposed to maybe just 1 or 2 people saying, hey, let's just talk with this person and I'll report back and other people join. So it's going to be pretty fact specific. What I generally recommend in terms of my best practice, if you have a situation like the one you described, I would either see if you could assign the task to staff, because staff is never subject to the public meeting because they're not elected officials. And if you can't, is there just one council person who can do it because they're not really a committee? It's just we've assigned Counselor X to handle this task on behalf of the council as a whole. But that's a good question.
Quick question.
Yes.
Does this also apply to subcommittee?
Yes, it does. So if your planning commission creates a subcommission to, let's say, review your development standards in the residential zoning districts, that subcommittee that's setting those zoning standards is going to be subject to the public meetings law. So as a former staff person, what I always like to put a plug in is committees and subcommittees are super great, but just be mindful that when you start to create this many and they're all subject to public meetings law, that generally requires city staff to support those committees and subcommittees because they've got to do the notices, the meeting minutes, and all of the other requirements they do for you at city council. So just keep that in mind. Any other questions?
Yeah, I actually have a
Yes.
quorum question. So this is a study session right now. Let's say we didn't have quorum. Let's say we
Mhm.
only had 3 people show up. Could we go on with the study session or not?
So typically what people suggest is that if you're going, there's no hard rule. So what people typically say, so I'll say for my board, when we have study sessions and I don't have a quorum, I make it clear that we are not going to discuss anything that's even remotely related to actual board business, that this is just going to be a straight lecture-based issue, and that if they have questions or concerns, we're going to compile those and they will be answered in a publicly noticed meeting where I have a quorum present, just to be on the safe side. Because what tends to happen sometimes is when we don't have a quorum present, we move our way into discussing city business, because the one thing everybody has in common is city business. It's not deliberate, and so we can end up creating some problems. So the public meeting, as we all know now, thanks to COVID, it's going to apply whether you're meeting in person, whether you're meeting via the telephone, or whether you're meeting through Zoom or some new technology that we've not yet created. It's really not how or where you meet. It's just the simple fact that you convene together as a group that triggers the application of this law. And then your quorum requirements are going to vary depending on your council size, your committee size, or your subcommittee size. So just make sure that you know what your actual committee size is so you can determine what quorum is. Okay, so legal requirements. These are not generally something I encourage elected officials to know by heart. You are going to have your city manager, your city recorder, and your city attorney who are going to help you, but you should have a general kind of concept of what they entail. So the first is you're required to give written public notice, and that notice has to give notice to anybody who's interested and the media. And so you have to give that notice at least 24 hours in advance under state law, unless it's an emergency. And I say under state law because I have seen some cities who have longer notice requirements in their charter or their municipal code. So for example, sometimes I've seen it's more common with committees than councils, but committees have to give 3 days notice or 5 days notice. So you want to make sure that you comply with both the state minimum of 24 hours, but if there's this more stringent requirement at the local level, you also have to comply with that. You can meet in less than 24 hours notice if there's an emergency. And an emergency means an actual emergency. I think that word tends to be overused and misunderstood today. So it's not an emergency if the council's going to have a bad day on the front page of the paper tomorrow. It's not an emergency if lots of people are going to be mad. An emergency really should be considered as there's a threat to public safety, a threat to life, something that literally requires you to act now. And less than 24 hours notice. And if you have to have an emergency meeting, LOC staff strongly recommends that you consult with your legal advisor, because there's certain things that you have to do in that meeting and in your minutes if you're having an emergency meeting to fully comply with the public meetings law. Your meetings have to be held within your city's jurisdiction most of the time. There's some exceptions for that. So let's say the City Council of Talent and the City Council of Medford wanted to get together to work on a joint project, and you wanted to have an in-person meeting. You obviously can't all be in Medford and Talent at the same time, so you could move that meeting, say, to Medford, and that would be perfectly acceptable. This exception also came into play, ironically, in the early days of the COVID-19 pandemic. Some of our more rural communities did not have facilities that were large enough to do social distance seating, and they did not have the technological capabilities to do Zoom. They don't have broadband sometimes. And so a lot of, I would say at least 2 or 3 cities that I'm aware of had to move their council meetings out into the county or adjoining cities. In one instance, I know they were holding their meetings in a barn out in the county. So it's normally your city's jurisdiction unless there's a reason why you can't. Your meetings, when they're in public, have to be in an accessible location. And that's not just for your, what I think people stereotypically think about accessibility. It's not just, is it accessible for persons who may need a wheelchair? It's accessible so for persons who may have hearing impaired capacities, who may be visually impaired. It needs to make sure there's no discrimination. So you can't hold your meeting at a place that says women aren't allowed to attend. Seems like it would be particularly problematic for your council, but in general, that's not something that you can do. The other major legal requirement that you have to be aware of is that minutes of the meetings must be taken. Your minutes can come in any form. Most cities that I'm aware of still require written minutes, but under state law, audio, digital, and video minutes will suffice. So you don't necessarily under state law have to take written minutes. In my experience, the written minutes are typically required by local rules as opposed to the state statute. There is a difference between what is required for minutes versus a transcript. So minutes are intended to be a summary that provide a listing of all member presence, the motions that were made, the outcomes of those motions, the votes of each member, and then the substance of any discussion or a reference to any document. It's not meant to be a transcript. What I always tell people who write minutes for the first time is most of the time you're going to write way more than you're required to under state law, but you just have to give enough information so a person could reasonably understand what's happening. In my experience too, and I think you guys record these meetings, most cities are still having an audio or digital backup of the meeting as well as written minutes. So if your written minutes aren't as detailed as you would like, you're probably still compliant because you probably have a digital archive somewhere as well. And that's all that's required under state law.
Question?
Yeah.
If we have both minutes and an audio or visual recording, is the audio or visual the official record or the minutes?
It depends on what your local rules say. So if what you're moving and adopting for approval of minutes is the written, it would be the written record would be your official written record. Your digital copy would still be subject to disclosure pursuant to a public records request or a court ordered subpoena, though you'd want to get both.
Thanks.
Mm-hmm. So serial meetings, I can't see all of you, but does everybody know what a serial meeting is? Anybody not know? Okay. I'm going to explain it just to make sure we're all on the same page in case. So a serial meeting is essentially a series of separate individual conversations between council members that result in a quorum having been met. Those separate conversations can happen in different locations, through different mediums, and at different times, and still equate to one meeting of the full council. So let's say, for example, 7-member council quorums 4. Let's say you're thinking about raising the height restrictions on homes in single-family residential zoning districts. So right now you have a limit on 2 stories and you're thinking about raising it to 3 stories. If the mayor and the council president have a meeting on Monday, they run into each other in City Hall outside of Jordan's office, and they start talking about that proposed ordinance. There's just 2 people, so we don't have a quorum, and that is seemingly okay. And then the mayor, 2 days later, gets on the phone and calls another council person to share a recipe. And in the process of sharing that recipe, they start talking to the ordinance. We now have 3 council persons who have talked about that ordinance. The council who was on the phone sharing the recipe a few days later is emailing a 4th council person, and they're trying to coordinate pickup of their kids' soccer, right? So both kids are on the same soccer team. Is it your turn to pick up, my turn to pick up, who's going to pick up the kids? And in the course of those various email exchanges, they start talking about the ordinance. We've now had 4 council persons who have met in a series of separate meetings, and we have a serial meeting violation. You have violated the public meetings law because a quorum of the council has conducted business outside of a publicly noticed meeting. That will be a violation of the state law. It can subject both the city and individual councils to personal penalties under state law. So individual counselors could be fined and have to pay those fines themselves. The city could also be subject to some legal challenges as well and have to pay penalties. The biggest case for this was called Handy versus Lane County. Some of the Lane County commissioners were personally fined upwards of $20,000 for violating the public meetings law. So there's some pretty big teeth to this particular issue. The trouble with understanding the serial meetings law is you can't find this anywhere in statute. It's a construct, at least in Oregon, that's completely created by the courts. So there's some things we don't know. So the situation I gave you, all of those conversations happened in 1 week. I don't know if that's long enough. By that, I mean, what if those conversations had taken place over 6 months? Could you still be in violation if it happened over 6 months? I don't know the answer to that question because we don't have any guidance in statute form or from the courts. We just have this one court opinion that says those series of meetings is problematic. In my experience, most serial meeting violations are completely unintentional, right? You're not trying to break the rule. You're just normal human beings and you're having a conversation. And what I think a lot of times happens is if we go back to the very first chain in this conversation, the mayor and the council president, you're having this conversation, you remember attending my training and you think to yourself, it's fine. What Patty described is never going to happen because the two of us are not going to talk about this with anybody. I promise. And then when the mayor's on the phone talking with another council president, she thinks to herself, well, I know the council president's not going to talk to anybody because we agreed we wouldn't talk to anybody. So I'm going to go ahead and talk to this other council person because it's only 3 and we'll still be less than a quorum and we won't have a problem. And the mayor tells the person on the phone, don't talk to anybody else because if you do, we could end up with a quorum issue and we could have this whole problem. And then the council president, unbeknownst to the mayor and the other council person, thinks, well, I know the mayor's not going to talk because she promised me she wouldn't say anything. So it's no big deal if I talk to this 4th council person. That's how it tends to happen. So what we generally tell people, the most conservative approach for serial meetings is, if it is a matter of city business, you talk about it at a publicly noticed meeting. If you're looking for some flexibility and some leeway, another option may be to have communications with the city manager, sort of as a go-between. So I'll use myself as an example. The league's board of directors is a public body and it's a governing body subject to the public meetings law as well. So if a quorum of my board talks in kind of the way I talked about the serial meeting, we could have an issue. So let's say my board's considering a bylaws amendment. And I can tell from our last publicly noticed meeting, we don't have consensus on what they want that amendment to look like. But I have some ideas of where there might be some compromise. I can contact the individual board members myself, and I can say, I'm just trying to get a feeler for where you stand and how you think this might work. Here's some suggestions. And if I don't share the information that I've learned from other board members with them, I just keep it, this board member communicates with me and I don't share anything else, we're probably okay. We probably don't have a serial meetings violation. And the reason that is because I am not a member of the governing body. So I could talk to every single member of my board of directors, and my board has never met separately or individually with each other. Each of them have met with me, but none with each other. I think, and most municipal lawyers think, that is a technically correct reading of the public meetings law. I do oftentimes caution smaller cities like yours to be mindful of using that and to consult with your own legal counsel, because I do think at some point a city will get sued for that type of action. And I think they will win, but the question is, do you want to be the city who gets sued for doing that? Because I do think there is an argument that that might not be within the spirit of the statute. But I think it certainly meets the letter of the law. Any questions on serial meetings?
I do.
Yeah.
And Patty, I think I'm remembering when we had this training some years ago, and I think there was something about the subject of discussion would be, or maybe it was written into law of some pending business for the city versus you know, the mayor tells me about a funny incident in the city that happened years back or something. I mean, you could technically say that involves the city, but it's.
Yeah, so it should be something that's related to the work of the city itself. Where it gets even more gray though, is what does that look like? So, so you guys live in Southern Oregon, you have had some catastrophic wildfires, both in your community, near your community, you're greatly impacted by smoke each year. You may not have anything on your agenda this year whatsoever to deal with fire response or smoke response or anything like that. So if some of your councils start talking about, wow, fire preparedness or cities responding or what we should do, there could be some concern that while you may not know that this is actually going to be before the city council this year, it's reasonable for an issue like that to actually come before your council. So what we typically tell people is if it's something that even potentially could be an issue for your current council to work on, to consider, to gather information on, it's best not to talk about it. If it's something about like, hey, that Christmas party 2 years ago, that was amazing, we had such a great time, that's fine, that's not city business. But just be mindful of what is likely to come before you, even if it's not for sure 100%. And the reason I say that is, again, Oregon's serial meeting law is not in statute. It's this judicial opinion that we're interpreting, and we're guessing how the court's going to come out on it. Other states have done it differently, and they've actually put it into statute, so we know exactly what we can do and exactly what we can't. So it's a little bit easier in those areas to operate. Any other questions?
Can I just expand on your example? So I think that the issue is like, it could come before us, even though if it isn't there, if it's something that's already come before us and we already voted on,
As long
can
as
I
there's
say,
not a-
why'd you vote like that?
As long as there's not a likelihood that it could come back. And
Okay.
so in that particular instance, be particularly mindful. I'm not entirely sure what your council rules of procedure are, but some council rules have a period of time in which an issue can be brought back up. So like, even if something was voted down or it was voted affirmatively, it can't be revisited for a period of time. That's make sure you're not going to run afoul of those rules. Because if it's something that, like, if it was like a 4-3 split and you know in 90 days when a local rule is over, you're going to bring it back up, I don't know that you want to talk about it.
That makes sense. Thanks.
Okay, so the other big kind of hurdle for public meetings are executive sessions. I'm sure you all have already participated in these, but an executive session is any meeting or part of a meeting that's closed to certain persons for deliberation on particular matters specifically permitted by law. So if you can see the slide clearly enough, we always highlight certain persons because I think there's a misconception sometimes with executive sessions. The council gets to choose who can and cannot attend the executive session. So let's say, for example, so there's a big homelessness case that came out of the Ninth Circuit a few years ago. You may have heard of it, Martin v. Boise. There's another one that came out of the district court in your area called Blake v. Grants Pass. And those judicial opinions talk about what is or is not legal with camping ordinance, sitting, sleeping, or lying ordinances. So let's say those decisions had just come out and you guys think to yourself, ooh, I think we might have an ordinance that's similar to what Grants Pass did or what the city of Boise did. We should probably have a conversation with our attorney in executive session about whether or not our ordinances are problematic. You may reasonably want to have, obviously, your city attorney and your city manager, but maybe you also need your police chief there because maybe it's the law enforcement officers who are enforcing that ordinance. Maybe you have a community development director or parks director who should also be in that executive session to explain how the ordinances have been interpreted or enforced, because those may come into play. And it's perfectly acceptable for the council to invite the police chief, the parks director, the community development director to your executive session. So it's closed to certain persons and you can decide who comes in, with the exception of the media. So the news media has a right to be present in your executive sessions. This is a unique factor in Oregon. It is not common in other states. They do not have the right to report on what has happened in executive session if you tell them they can't. So most cities have a script that they read at the start of the executive session, and it basically says you can't disclose anything. Now, I will tell you there's no punishment for disclosure in the statute, so if they ignore it, there's no penalty. To my knowledge, sorry, Sorry, we've got staff should be gone by now and they're not, and they're having a little too much fun if you can hear them. I lost my train of thought. So there's no penalty if they violate the executive session statute. But I will say historically, the traditional news media recognizes that Oregon is an outlier in letting the media attend executive sessions. So they have complied because they don't want to lose that right. When you hold the executive session, your notice must list the specific statutory reason for which you are holding the meeting. So you can't just simply say, we're going to have an executive session. You have to say, we're having an executive session pursuant to this Oregon statute, and then cite the reason for that Oregon statute. And we'll go through some of those reasons here in a minute. You cannot reach a final decision in executive session, but you can know what the decision is going to be. So we'll take, for example, one of the most common reasons city councils hold executive sessions is because you're interviewing for a city manager. Not that Jordan's going anywhere, but let's say Jordan wins the lottery and she says, peace out, I'm done. I'm going to go live on the beach in Tahiti. And you have to find her replacement. You obviously can do interviews in executive sessions, and you can review the results of those interviews in executive session. So you can all be together in this executive session, and you don't have to go into the public meeting not knowing what the consensus of the group is. So you as a council can sit down in this executive session and come to the consensus that the person we want to replace Jordan is Marilyn Jones. But the decision to hire Marilyn Jones can't be made in that executive session. You have to go into a public meeting and do a motion to hire Marilyn Jones as the next city manager for the city. So you can know what the decision is, you just have to actually make it in the public meeting. And then the key thing for the recorders to know, because they're unfortunately the ones who usually get stuck with all the meeting notice requirements, is that all of the other legal requirements for a public meeting apply to executive session. So there still have to be minutes, there still has to be notice, they still have to be in an accessible location. All of those requirements are still the same for executive sessions. Any questions on any of that? Okay, so reasons to hold executive sessions. So I'm not going to go through all of them under state law because a lot of them aren't applicable to cities. So we'll just touch on the big ones that generally come into play for cities specifically. So you can have an executive session to consider the initial employment of an officer, employee, or staff member, but not to fill vacancies on your own council, right? You can't have executive sessions for them. The tricky part is, though, if the executive session is because you're filling your city manager position, that position has to be advertised. You've had to previously adopt a standardized hiring process in a public meeting. And in that public meeting, you have to have sought input from the public on the process you developed. So Jordan wins the lottery, she's out. You take an opportunity to review the job description and the hiring process you want to use to replace her. That part needs to be put together at a public meeting, and the public has to be given an opportunity to comment on it before you start the actual recruitment. So you build the job description, you build the desiring hiring process, you present it as a draft at a council meeting, you take comment on it, and then you adopt it. If you do all of that at a public meeting, then you can do your interviews in executive session. You can conduct employee evaluations in executive session, provided the employee does not request an open hearing. So employees at their discretion are allowed to say, no, I want you to do my annual evaluation in a publicly noticed open hearing. That's up to the employee to decide, not the council. If you want to dismiss somebody, because charges have been brought against them, or you have a complaint that's been filed against them, you are allowed to do those types of meetings in executive sessions. But again, the employee in question has the right to request that that hearing happen in a public meeting. So if you were going to discipline, let's say, your city manager, the city manager can say, I don't want you to do an executive session. I want you to do this in a public forum. And in which case you'd have to comply with that. You can conduct labor negotiations or discuss labor negotiations with a negotiator. So let's say, for example, you guys have an AFSCME union in Talent and you've hired Joe Smith to negotiate that contract on your behalf. The council and Joe Smith can meet an executive session to discuss the negotiations. You can also discuss real estate transactions with a real estate negotiator if you've hired one to purchase or sell any city-owned property. To review security programs, if those programs are related to utilities, telecommunications, or data transmissions. So if you own any utilities, telecom, or data transmission lines or facilities, and you need to review the security protocols related to those, you can do those inside an executive session. So we put these together, some of these together as kind of not a workaround, but a way how to. So you are allowed to consider records which are exempt from public inspection in executive session. You're also allowed to consult with an attorney about current litigation or litigation likely to be filed. But a lot of times you need legal advice, but you've not been sued and you don't know that you're going to be sued. So if we go back to those court decisions I talked about that dealt with camping ordinances, if you had had an ordinance on the books that regulated or prevented somebody from sleeping, lying, sitting, or camping on public property, and you had not been sued and did not expect to be sued in light of those court decisions, but still wanted to meet with your attorney and get some legal advice because you were worried you might have a problem, how you meet with your attorney in executive session is you contact the attorney and you say, I need a legal memorandum or a legal opinion on whether or not our ordinances are impacted by these recent court decisions. Your attorney then writes you a written legal opinion. That legal opinion is a record which is exempt from public inspection. And then you hold an executive session to consider records which are exempt from public inspection. You invite the city attorney to that meeting and he reviews the legal memorandum with you and you ask them questions in the executive session related to that memorandum. That's how you get confidential legal advice from your attorney when you've not been sued and you don't believe you're going to be sued. You use the records exempt from public inspection. Two things to note with this. If you use that exception, you actually need a written legal opinion from your attorney. And you need to invite your attorney to the executive session. So I have seen some cities who have tried to use that, but don't actually have a written record from their attorney. So there's no record for them to consider, or they failed to invite their attorney to the meeting. You have to do those two things for this exemption to be valid. You can also have an executive session if you're going to conduct trade negotiations, if you're competing with governing bodies from other states. I don't know what that would look like, but in the event that you have that opportunity, know that you can certainly do it in executive session.
Question?
Yeah.
So taking the camping ordinance as an example, would the decision to consult with the attorney on the ordinance have to be made in open session by the council?
There's two ways I would do it. So I say this was as a legal background. So you could certainly do it that way. You would have to do it in a public meeting. I don't know what your rules are for how you hire and use your city attorney's advice. So I've seen some councils where the city manager can do it on their own, the mayor can do it on their own, each councilor can do it with only 1 or 2 hours, or the full council has to agree to do it. So start with your legal rules on that. But generally speaking, in those types of instances, if the council's kind of talking about something, it probably makes more sense for Jordan to say, we probably need a legal opinion on that. Let me contact the lawyer and I will handle that and schedule the executive session accordingly. Because you want to be mindful of if you think that you might have a legal issue, you want to be mindful that you don't somehow threaten your city's legal standing because you talked about things prior to getting advice from the attorney themselves. Does that make sense?
Yeah, it does. I'm also thinking about, if you're tipping your hand essentially, and how to get that, the attorney opinion with. Well, let me ask you this. If say we did have an executive session to review a memorandum like that was specific to an ordinance, the reason given would just be the statute. We wouldn't have to say anything about the subject matter. So it
Yes,
could kind of,
yeah.
it could be anything as far
Yeah,
as
so
people knew.
I'm going to get the code statute wrong, but what it would say was the city of Talent is meeting an executive session pursuant to ORS 192-605 subsection B3 to consider records exempt from public inspection. That's what your notice would say.
So that would be the most cryptic way of all.
Yes.
there'd be people wouldn't know what it was about.
Yes, yes.
Cool.
Any other questions? No? Okay,
Patty, I have a quick question.
yeah.
And Hector, our city reporter, could probably answer this as well. Does an executive session have to be within a public meeting, or could we just post an executive session?
You could post an executive session if there's no decisions to be made. So let's say, so one of the most common ones is, let's say you are interviewing candidates, right? Let's say you've got 6 candidates to interview. You could do 3 executive sessions in one day with no public meeting, because the next 3 are the following day. So you can hold executive sessions to get information and advice. So let's say you are in the middle of litigation and there's absolutely no decision to be made. Your attorney just needs to say, this is where we are, this is where we're going, and you're not giving them any direction, then there's no need for a public meeting afterwards. What I don't particularly personally like is some cities like to throw executive sessions on every standing agenda. That makes me nervous, because I don't know that you've specifically stated the reason with the statute at issue, right? So the notice requirement requires you to say which statute and which reason you're holding an executive session, not just we may have an executive session today or not. So it's perfectly fine to have standalones, and it's perfectly fine. So for example, one of the ones I've seen some cities do is one of the ones my board's considering doing. So the executive director's annual evaluation has always happened immediately before the December board meeting. And last year they decided that's really, it kind of throws off the board meeting, because the executive director is a little like angsty and doesn't really know how it's going to go. So they've decided to put the executive session review 2 days before the board meeting. They won't make any decisions in that executive session. And then when they go to the public meeting, they'll make their decision, but that gives some space for the executive director to kind of be in the right headspace for the full meeting.
Just to follow up on that, I think we've done meetings in the past where it really was just for an executive session, but we still started with a public meeting where we did the roll call, and then we said we're going into executive session. So you have to start it at least the beginning. You don't?
Nope.
Okay. So we
And
can
at
do
the-
the roll call and
yeah.
everything in executive session.
Yeah, and what you probably have a standardized script, I'm going to assume, for your executive sessions, right? So same thing, you're just going to take roll in executive session, make sure everybody's there, read your script and go in. Now I said that's under state law. If you have a local requirement, which is possible, then you'd want to follow the local requirement if it's more stringent. But under state law, you can have a standalone executive session all by itself. Okay. So what happens if you hold an executive session you shouldn't have? So that's going to be investigated by the Oregon Government Ethics Commission. They're the entity that hears complaints and renders decisions about those types of violations. Fines are against individual city elected officials. It's not against the city. And the city can't subsequently pay those fines on your behalf. So what I always tell counselors is, if you think your counsel is holding an illegal executive session, leave the room. Because you will be personally liable for those fines. So if you go back to the Lane County commissioners, as I said, some of them got $20,000 individual personal fines. Maybe that's not a lot of money to some people. For me, $20,000 out of my checkbook would probably result in my husband having some significant issues with me. There is a safe harbor provision. I'm always hesitant to say this because I know smaller cities like yours don't have an attorney that's necessarily on staff, so it probably costs you money every time you talk with them. If you contact your city attorney in advance of an executive session, explain the reason why you think an executive session is warranted. And if your city attorney says yes, those are legitimate reasons to hold an executive session. If they give you permission to do it and the city attorney ends up being wrong, there's room in the statutes that allow the Ethics Commission to forgo issuing those personal fines. So it's almost like a safe harbor provision. And in my experience, what the Ethics Commission has done is, if you have been improperly advised by your attorney, then they're not going to hold you personally responsible for those fines. So sometimes the couple $100 you spend asking your city attorney for their perspective on whether or not you can hold the executive session is worth it in the end if they end up being wrong. Because if you do it and you're wrong on your own, those same harbor provisions don't apply. You've had to have asked your city attorney first. Okay, so then public participation. So most of you, I'm going to assume, allow the public to participate in your meetings. Is that fair? Okay, so a lot of times people think that you are required to allow this participation under state law. That's not typically true. Even the Oregon Attorney General will tell you that Oregon's public meetings law is really a public attendance law, not a public participation law, which means the law requires you to allow the public to attend, witness, listen to your meetings. It does not require you to allow them to participate in those meetings, with some limited exceptions, the two biggest being land use hearings and your budget committee process. What does happen though is virtually every single city has some type of governing document that requires the public to be allowed to participate in their meetings. I think this is a good thing. I'm not saying that's a bad thing. I think you work for the citizens, you represent the residents of your community and the businesses, and they should have a right to seek redress through their public officials. But the requirement that citizens and residents and business owners be allowed to participate in your meetings is usually because of a local document, not state law. So you want to look at your charter, your ordinances, and the council rules of procedure, because that will tell you when and who and how the public can participate in your public meetings. Now, once you let them participate in your public meeting, free speech rights are triggered. And there's two types of free speech rights in Oregon. The first are protected by the First Amendment to the United States Constitution. And then the second are protected by Article 1, Section 8 of the Oregon Constitution. I will tell you that the Oregon constitutional free speech provisions are much broader than the First Amendment free speech protections under the US Constitution. So just know that once you allow them an opportunity to speak, those free speech protections apply to the speech that they're about to provide.
Question?
So, yes, go ahead.
Yeah, so I'm just wondering how broad that is. I mean, sometimes we talk about not letting people, speak in a way that's disrespectful or whatever. I'm wondering how far, if say, if a person were to, a neighbor were to say stand up and say, "Oh, I'm neighbor A and my neighbor B is a Nazi," or just something awful.
Yeah.
Say, is that protected speech?
Potentially, but not always. So let's get into that. So what you can do is you can regulate what are called time, place, and manner restrictions. Sometimes you'll hear lawyers talk about TP and Ms. That's what these are. So what you can do is you can regulate essentially the time that the public is allowed to speak, the place from which they can speak, and the manner in which they can speak. And in practice, that means that you can dictate the time for public comment. So they're only allowed to speak during this specific time. And if they speak from the audience or they speak out of turn, you can ask them to sit down. If they refuse to sit down, you can ask them to leave, or you can have them removed. You can dictate the specific location from where public comment is made. So if you're at an in-person meeting, it's you have to make your speech from this particular table, this particular podium. We don't take comments from the gallery. You can limit the topic of the comment, but you need to be careful here. And by that, I mean, if it's open public comment, right? So it's anything they want to talk about, it's anything they want to talk about, right? If it's like only on this particular ordinance, then you can say your comments have to be limited to this particular ordinance. You can describe the length of time, so they can have 3 minutes and only 3 minutes, but you have to treat everybody the same. So you can't let, what I always like to say is the Girl Scout example. So when the Girl Scouts are selling cookies, if your time limit is 3 minutes during public comment, you can't give the Girl Scouts 5 minutes because they're cute and they're pigtails and everybody wants to buy their cookies, but give the rest of the public 3 minutes. If you want to give somebody longer time to speak, then you want to make them an actual agenda item. You don't want them to come during public comment. You've got to treat all speakers equally. And when it comes to the content of the speech, so things like using cuss words, being demeaning or derogatory or saying unkind things, it is fairly common and appropriate for you to have council rules of procedure that prohibit that type of language and that type of discourse. It's appropriate for the mayor or who's ever serving as presiding officer in the mayor's absence to remind people of that. But you also want to be mindful of how far you are willing to go to enforce those provisions. There's some pretty specific court decisions out there that indicate that certain curse words are protected speech. One of the most famous ones is from when the Vietnam War was going on. There was a high school student who had a jacket, and the jacket said, F the police, F the war, something like that. But it wasn't F, it was spelled out entirely. I'm not going to do that. And what the US Supreme Court said was the F word in that context was protected speech because that word conveyed a particularized message in a way that a different word would not have been able to convey. So it's perfectly appropriate to require decorum and expect it, but be careful about pushing it too far if it seems like it could actually be speech, which is a tricky tightrope to walk. So what I usually would tell my clients is if somebody's walking away from the podium and they say something unkind, kindly remind everybody that we are an organization that strives for decorum and respect and treating people professionally, but maybe don't make a giant case out of it. Does that help answer the question?
Yeah, thanks.
Mhm.
Although I was going to ask specifically about defamation and that sort of thing.
So defamation is a really hard bar for public officials to actually meet. It's more than we can probably encompass in the time that we have allowed. What I will tell you as kind of a hint is that the league hired a law firm to write a First Amendment guide for public officials, and we expect that guide to be released in the next 4 to 6 weeks. And there is a decent sized chapter in that guide on defamation that can give you some more information on that.
And I'm just wondering also the neighbor on neighbor defamation.
That's a little easier, but defamation is still a pretty hard bar, and it's not usually applicable when you're just calling people names.
Okay, thanks.
So a lot of times what happens is you will have somebody who is so out of line or so disruptive that you want to have them removed from meetings. That is perfectly appropriate, provided the person is actually disrupting the meeting. And the standard for that in Oregon courts is essentially that the behavior, the comments, and the actions are actually preventing the council from doing its job. So those little oh my God, really? Those are annoying and they're disrespectful, but you can still continue to do your business over them. But if somebody is standing up and they're screaming and they won't sit down and they've completely taken over the meeting and the mayor cannot get them to sit down, then they are taking away from the meeting and they're disrupting it. And those people can be removed. As a side note, as a former attorney for law enforcement officers, physically removing somebody from a public meeting should be the responsibility solely of a law enforcement officer, not some other city staff person, much less a sitting councilor person. A lot of times people will say, can we actually arrest people? Yes. Disrupting a public meeting is technically considered disorderly conduct under Oregon law. And so people who are actually disrupting public meetings are guilty of the conduct of disorderly conduct. Again, what the league will tell you is it's not appropriate for council persons to tell a law enforcement officer, I want you to arrest this person for disorderly conduct. Whether or not an officer chooses to make an arrest should be within their sole discretion. They're subject to certain standards and some certain requirements, and they need to be the person who makes the decision. What should happen is that you should ask the officer to remove the person from the room. And I saw a note from the mayor. I've got 4 minutes. I think I only have 1 slide left, Mayor. I think we'll be right on time. And the last question that I often get from people is, can we suspend people from attending future council meetings? The answer is probably not. What the federal courts have consistently held is that prospectively banning people from public meetings simply because they have consistently disrupted meetings in the past is probably not okay. The only exception, and they put these exceptions in footnotes, is that if you think the person poses a threat to somebody's safety, then they would consider that you might be able to temporarily suspend them from future meetings. If you get to a place where you think you need to suspend somebody from a meeting, then we always at the league strongly encourage you to contact your city attorney to discuss whether or not you have an actual legal basis to do so. That would be my presentation.
That's fantastic. And thank you so much, Patty, for coming. We have a couple minutes left. So if there's any other questions that council may have, or staff?
I have a very quick question.
Yeah.
Public meetings for events. We're having an Arbor Day next weekend, and we hope that council will be present in a quorum just as participants. Would that require public meeting notice?
So not technically, what I would say is some councils, when we're nervous, particularly if you've got some hot button issues that are brewing and you know they're going to talk about it, even if they shouldn't talk about it, is I would just notice them to be careful. I've seen city councils who've just been like, just notice it because we don't trust ourselves not to break the rules.
Perfect. Thank you.
Yeah.
Okay, are there any other questions or comments? All right, seeing none, we're going to go ahead and adjourn this meeting, and we will convene as council on the same link. So everybody who is attending as an attendee, please know that you don't need to go anywhere. We're going to close this meeting is now closed, and we'll start the council meeting. Does the council need a couple of minutes break? Great. And before we go, again, Patty, thank you so much. These ongoing trainings are so helpful. And as I said the last time we had a training recently, I've taken these trainings over the 20 years that I've served this community, and I learned something new every single time. And so it's so valuable for us to do this annually.
Excellent.
So
Well,
thank you so much.
thank you for having us and trusting the league to provide these services. And y'all have a good rest of the evening.
Thank you. All right. So we'll give everybody about 2 or 3 minutes, and then we'll start up the council meeting if that works for everybody. Okay.
Thank you, Mayor.